developments? Right there, guys. Okay, there we go. Who here manages condos? Okay, everybody, this speech is for you, so that's good. Because you're like, oh, I could tune her out if we were only planned developments. You're like, no, I find them all in one. Okay, so, yeah?
Sorry.
Of course he's gonna come back in. This is Steve.
Sorry, man. I'm just trying to save myself $5.
There you go. Okay. So, who here has received or had to go through an ADU application from a homeowner? Literally no one in this room? Okay, we've got a couple. All right, so how happy were your boards? I'll just give you this one little story. So Thursday, as in like yesterday, I'm on a call with a board, and these people are bougie. They did their $3.5 million houses. They got an ADU application, and they're like, we don't want this for us. How we're gonna make this stop? And I said, oh, I love that for you, but actually you're gonna have to learn how to say yes to ADUs. And they were like, no, actually we're not. So this is all about the statutes, ADUs, and why you have to learn to say yes. So a couple years ago we got civil code. It was amended, the Davis-Sterling Act, so the one that we all fought through. And it was actually amended to require homeowners associations, planned developments, not condos, planned developments. They cannot unreasonably restrict or otherwise prohibit accessory dwelling units. Straight up, you can't say no. Government code governs government. It's like this whole long litany of stuff that's like words, 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 but it's like this high, this big, this many feet, this stuff. That's what ADUs are in the government code. Then you're going to have your city or your county ordinances. Why do your city and county ordinances matter? Because those are the ones that actually apply. And the way the government code was drafted, it was basically drafted to say, here's the minimum. It can't be more restrictive, but it could be less restrictive. Because the public policy behind ADUs, whether any of us in this room agrees or wants to accept it, the public policy is that it's part of the state's solution to affordable housing. So on a super high level, ADUs are absolutely here to stay. Notwithstanding any boards that are like, no, this is going to really be fixed, associations will be exempted. You're like, no, 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 that's so cute. They're going to be here. So now that we understand their statutes and the government code and the Davis-Sterling Act and in each of your cities and counties, whichever one applies, I have one HOA that literally is like, some streets are in the county of, Contra Costa, other streets it's in the city of Danville, so that's super fun when I get those ADU applications, because I'm like, I actually need to know the specific street so I can correctly analyze which one applies. So here's the potholes that you need, these are metaphoric potholes, that you need to kind of be aware of for any of your associations that are going to be on the receiving end of ADU applications. And here's the reality. So the ADU statute was passed in 2020. Then COVID happened and we all hunkered down for like a year or two in our houses. And so ADUs were not a thing. But people are starting now to like poke their heads out from like gophers. And they're realizing, oh, hey, I can like build a mother-in-law unit. That's what they're called. Sometimes they're called granny flats. Other people look at them and they're like, I could shove my kids in the yard. That's a good place too. So these applications are going to start being submitted more and more with greater frequency. So first of all, you need to understand that ADU applications need to be handled in a timely and expedited manner. One of the things, an accessory dwelling unit actually changes the density of a person's lot. And by density, I mean, hey, it used to just be a single-family home. There'd be a family in there, whether it was a family of 5, a family of 2, it didn't matter, it was just a family. An accessory dwelling unit is literally a separate residence that is, in theory, able to house an entirely separate family. And so why that matters is, before the laws were changed in 2020, you would have had to go through like a city planning, public hearing, like all these, extensive processes in order to get this type of approval. But the law's changed and it literally says these are ministerial approvals. And so it matters because you literally show up with your ADU application, you go to the planning department counter and they stamp it. That's how easy it is for a homeowner to get an ADU approved on the government side. So that also means the association needs to act on an expedited basis as well. Look at your CC&Rs. They're almost always going to say something like 30 days, 45 days. Sometimes they'll say 30 or 45 days. If you haven't given us an answer, then it's deemed approved. In bad cases, it'll say the opposite, 30 days or 45 days, it's deemed denied. That's not a good provision to have, but that's a different topic. So, boards need to understand that the county or the building department, they can approve an ADU. It doesn't mean that the board has to accept the ADU, but it does mean that the board needs to really treat these with an exigency. They need to be Johnny on the spots with this. And from a management side, I understand, like, y'all are overwhelmed. I know some companies actually have architectural divisions where the applications get sent and facilitated. Just appreciate that these need to be what I'll call like specially tracked or flagged. So I'm telling you, you can't say no to an ADU, but what can you say? So the law allows for reasonable restrictions. So let's go over some of what those could be. Yes, you absolutely can, in my opinion, require aesthetic and architectural consistency and cohesion. If you've got a Mediterranean-looking house, you could prohibit the person from installing a, modern cubist-style structure. I don't know who would do that, but we all know there's crazies out there. That's why we have jobs. Everyone knows this. So, alright, we can require aesthetic consistency. Could you require screening materials? Let's try to put some vegetation or some kind of screen up that sort of minimizes the visual impact. Yeah, I actually think you can. Could you establish what kinds of documents or the process that a homeowner has to follow in order to submit an application? Absolutely. So in those list of documents, you may want to require a survey, like an engineering survey of the lot so that you can understand what are the established grading patterns, what are, any applicable slopes, sewer lines. Like, you need to know all of that because otherwise you're asking for trouble. Most CC&Rs, at least in plan developments, will have things like, thou shalt not change drainage and grading patterns. So if that's what your CC&Rs say, then have a rule that says you need to let us know what those are. Because a lot of homeowners are downloading ADU plans off the internet and being like, hey, look, I spent $40, I got plans, I'm just going to submit that and hope for the best. Well, your boards actually have to protect your communities, so require more documents, but you can't require them if you don't have a policy that specifies it. So, you absolutely can prohibit the short-term rental of ADUs, so that's good-ish. You can require a recorded covenant. Most ADU statutes and ordinance will actually require a covenant from the city or the county standpoint, so I say pile on. Have more recorded covenants. Why not? You can. And the purpose of the recorded covenant is so that it is expressly clear. There's an ADU, here's all of these terms and conditions that come with it. You can't sell the ADU separately from the lot. That's important, because otherwise, it's literally going to get its own address. So you kind of want to make sure that, look, we all know there's shady people. If there weren't none of us lawyers in here, we would have jobs. So we just have to understand that. So a couple things that boards need to understand are definitely overruled from CC&Rs if the CC&Rs are more restrictive. Setbacks. Your CC&Rs, let's say they say you have to have structures no closer than 10 foot from the backyard or from a side yard. Well, the ADU statutes allow that thing to go 4 feet from the sides and the back. Think about that. You're like, wow, 4 feet is closer from here to the edge of the stage. That's kind of scary. It freaks people out if don't have context for how the courts are analyzing this, and that's important. If there's case law, then attorneys can go and analyze stuff, but we don't have that yet. So on the maybe list, I'm throwing them into the policies just because I think it's important that it at least sparks a dialogue. Preferred locations. And this is something that really gets a lot of the homeowners and the boards, they're they start flapping their wings because they're I don't actually want to see the ADU. I don't care if they have one, but as long as it doesn't screw my view, then I'm fine. And so you can't force a homeowner. If you want the ADU to be over here and they want it to be here, I do not have a clear answer if you could force it. I don't think you could. But you can certainly put it as part of the policy that the board is requesting a good neighbor policy behind where ADUs are located, that you are asking the homeowners who are trying to construct these things to be mindful of sight lines and view corridors, to be cognizant of privacy invasions from their neighbor adjoining lots. So these are things that I think you can put into an ADU policy, but again, you can't prohibit it if it's not there. And so one of the big takeaways is have an ADU policy. If you have a planned development on your portfolio, you absolutely need to have a policy. Because it's not a question of if you're going to get an application, it's a when. And these things are definitely starting to circulate more and more. And I don't want any of you to be behind the 8 balls because the first thing that I said, expedited timelines. It's super impossible for you to go and adopt an ADU policy if you're now on the clock of 30 days to give an affirmative answer on an application. So I know that boards are tired of managers continuing to come in. So there's this policy we think you should have. They're like, those lawyers, they're literally bleeding us dry like vampires. And you're like, I know that, but that's what they do. They suck the blood out of you. So a couple things on how do we enforce ADU violations. Because I think, let's be honest, we're in a circle of trust here. There's probably a lot of folks who want to build an ADU, not so that they can house a low-income family, or not even so that they can house a mother-in-law, but so they can just have an office that's not in their house. It's true. And you sit there and you say, okay, well, ADUs, the intention, the public policy behind it is that you are being allowed exceptions to other recorded covenants because the public policy is, hey, we need to fix affordable housing and make housing more available. So if someone is building an ADU for the express purpose of, I'm actually just going to have my yoga or my exercise studio, it's really just going to be an office that has zero to do with serving as an actual separately occupied dwelling, I can't tell you that there is 100%, yeah, we're going to enforce on that one because, again, we don't have a case law for it yet. But there is one city that I have seen, their ordinance, their ADU ordinance, City of Mammoth Lakes, that literally has a use restriction in it. And it does say, this is a statute, so I'm sort of using it as well, at least there is one jurisdiction where this is acceptable. If you are not using the ADU as it was intended, then you're going to have to bring the ADU into compliance with all of the other statutes that would have otherwise applied because it's not an ADU. So it's something that I tell boards, this may be a thing, but it's too early to tell. So the takeaway on the ADUs and enforcement is engage in dialogues with the applicants. And, a lot of times boards are like, well, we just want to say no. And you say, this is not one where that's the reality. And so have this dialogue and also explain to the homeowners who are applying, here's what the requirements of ADUs are, and really try to understand at the outset, is this intended to be used as a dwelling? I don't care if it's unoccupied or not, but is it intended to house humans instead of, a gym equipment? So that's ADUs. We're going to bang through lot splits even quicker. So who here has heard about lot splits? No? Okay, we've got a couple people. So lot splits is literally when someone comes and chops their lot in half. I'm totally not kidding you. That's what a lot split is. So let's say square foot lot, and because of a law that was passed last year, I'm like, ooh, you know what I'm gonna do? I'm gonna maximize my value on this lot. I'm gonna go and chop it in half. So now I have two 5,000 square foot lots, and I'm gonna plumb houses on both those lots. That's what a lot split is. Because of our wonderful legislature who's so focused on affordable housing solutions, you can't just put one house on each of these split lots. You could put a duplex, which means you could, where one lot used to exist, you could have upwards of 4 houses. Who here thinks that's a recipe for success? I'm telling you, the legislature's killing it with this affordable housing business. So that's why associations freaked out so badly. You know, you may have heard, for people who have planned developments, you may have heard that, you know, starting rumbles the last, 6 months of last year, where they're like, if they do that, I'm moving. And you're like, I know, me too. So the statute behind lot splits is called Senate Bill 9. It was adopted last year. It took effect this January. And it literally added a whole litany of government codes, which if you remember what I just talked about, government codes govern the government, not HOAs. But it added this litany of, here's how we deal with lot splits. And Toni Atkins, she's the author of the bill, she actually gave us a gift, because I think we can all agree in HOA bill over here, when legislation has been passed as of late, it's generally bending us over, and not in a good way. Oh, who here liked the election rules? No one did. All of our boards were pissed. Rightfully so. They're like, we just adopted those like 2 years ago, finally. So, Toni Atkins, the author, she wrote a letter to the Senate, and it basically says, hey, as the author of this statute, I didn't intend, nor does it have the legal effect of actually modifying CC&Rs or upending community associations and their covenants. And that's a good thing, because what that means in lawyer speak is that SB 9 and the lot splits in the government code do not interfere with our CC&Rs that we have on the books. So now let's talk about the potholes and the recommendations regarding lot splits. CC&Rs, they are the problem and also our solution. So I have a client. Their CC&Rs are from 1946. It's so much fun for me because they literally have 26 separate tracts, and every single tract has its own special set of CC&Rs. And it's like combined about 3,500 homes. So amending them is going to happen in my lifetime for sure. The problem with this community is that it's in a very desirable area where these homes were clearly initially built in the 40s and 50s. Little tiny post-war homes. And now they can sell their homes for about $3 million a whack. So you do that math and you're like, yeah, if I could lot split and I had a lot in that community, you betcha I'd think about it. So the board comes to me in a complete panic because they're like, we obviously don't want more houses in our community. It's, in a very dense urban area. How can we stop this? And I said, well, let's look at the CC&Rs. What do they say? Unfortunately for them, their CC&Rs, all 26 separate tracts of them, don't have a thou shalt not further subdivide your lots. So that's a problem. If there were CC&Rs that had such a provision, yeah, you come to me, come to Steve, we're like, hey, can we prohibit this lot split? You're like, absolutely, let's do this. But they don't have that. And so that's one of the solutions is look to your CC&Rs. There are different types of provisions that may, arguably, give an association the ability to prohibit ADUs. You could have something that specifically references the number of separate interests in the community. Well, geez, if it says there's 142 lots in the community, you can't have 143 unless you amend the documents. If there's something that says, no further subdivisions, okay, that's a good one. So if your CC&Rs don't have those provisions and you're in a planned development, your boards, if they're concerned about lot splits, and it's not going to be a huge concern for every community, but in communities where you look at the economic value of what a split lot might be, those boards may actually want to take action and consider amending their CC&Rs. It's possible maybe they adopt a rule. That's a tough one because it lacks the legal effectiveness in the team. But, start on that as a dialogue. Perhaps one of the most important things is timely and proactive communications in this. I had a manager, and he's here today, called me a couple months ago, and he was like, hey, we've got a homeowner, it's literally in their ad, they're in the process of selling their lot, that this is, a great place for a lot split. I was like, ooh, we need to nip that in the bud. So we literally reached out to the agent, we reached out to the homeowner, and we really started the dialogue. We said, hey, just want to make sure you know the CC&Rs say XYZ, lot splits are not going to be permitted in this community. And they had a lot of pushback because this homeowner was clearly looking at monetizing his lot, double the price. And so because we were timely and proactive in it, it sort of fizzled out, and the homeowner tucked the tail between the legs and shrunk away and was like, all right, I'm upset about this. And I'm like, what you gonna do? So that's lot splits. Rental restrictions. Who here has had a client that has had to amend their CC&Rs because of rental stuff? There we go, handful. How many of you have looked through all of the CC&Rs for all of the HOAs that you manage and have confirmed that all of them are okay? Yeah. Oh, she has gold stars up here. I'm not going to give you a free note after this. I'm generous that way. Okay. So, Civil Code 4740 and 4741. So we're in the Davis Sterling world, and this matters because Davis Sterling is our jam, all of us here. So it was amended 2 years ago, and it expressly prohibits associations, all of them, the planned developments and the condos, so this is the all-inclusive jamboree, from imposing unreasonable restrictions or prohibitions that disallow a homeowner to rent their separate interest. It does allow for associations to impose reasonable restrictions. So, same thing that I went through with the ADU discussion, this law is so new, we don't have a lot of context, but we do have one case, I'm going to talk about it. So, the important thing here is that associations can have rules, but they must amend their governing documents, CC&Rs, bylaws, if there's things in bylaws, or your rules that conflict with what the civil code requires. And so if you have any CC&Rs that say, hey, rental caps 10, 15, 20%, that those must be amended. If you have CC&Rs that say things like, you're allowed to rent, but you have to be an owner for a year, or you have to live here for a year or two before you get to rent, those are straight up out. You can't even have those anymore. So those are the types of provisions in your gov docs that must be amended. So you ask, when do they have to be amended by? Does anyone know the answer to this? They have to be amended by the end of June. That's T-minus 40 days. I'm aware, so math is questionable. It's true. So that's a problem for a lot of associations because you're like, all right, well, we have CC&Rs. They say we have a 20% rental cap, and our homeowners approved it, so it's not like they're going to voluntarily amend the CC&Rs to go even higher. Well, the statute was amended again. Surprise, surprise. This January, where boards unilaterally have the authority to amend CC&Rs without homeowner approval to actually bring the CC&Rs into compliance with what the law requires. So, if you have any stragglers, and I know they're in here, please, for the love of Mary, get them to amend the CC&Rs. Why does it matter? Not that I want more work. Oh my God, no. We're busy. Because there is a potential civil penalty of $1,000 a whack. It's a small claims case filing, and we know there is one person or more in every community that is just waiting to sue. And it's like free money when it's small claims court, and there's literally a statutory statutory penalties. So it's important, amend the CC&Rs, you still have time. How do we amend CC&Rs if the law says boards, you can just do it? They did impose a process, it's like the 28-day rule adoption process. So just know that's why I'm like, we're sort of T-minus, almost not able to still do it, but there's time. So now let's talk about Brown versus Montage. I was so apoplectic when I read this case last year, I literally walked into Steve's office and I was like, I made a lot of noises, sounded kind of like a cat and a goat at the same time. And Steve was like, use your words, Jasmine. And I was like, And so this is why it's a terrible case. Came out last year, late in the year. So homeowner Brown, she buys her condo, early 2000s. And from the time that she buys her condo until now, this woman rented her condo on a short-term rental basis. She was Airbnb before it was a thing. And I'm like, good on you, lady. The CC&Rs at her community didn't prohibit short-term rentals. But now fast forward to, a couple years ago, the HOA decides, you know what? We kind of hate Airbnb. Amen to that. We don't want them, no more short-term rentals. And you come ask a lawyer like me, I'm like, well, of course you can amend your CC&Rs. Like, them's the breaks when you live in an HOA. Amendments are possible. So the association goes through a successful amendment, changes the CC&Rs. This homeowner, Mrs. Brown, does what every good American does. She sues. And we're like, oh, come on. Like, how can you sue? We amended the CC&Rs. Like, we win this one for sure. Except we didn't. We didn't represent them. The association lost the case. And all of us in this room were like, hey, if they successfully amended the CC&Rs and prohibit short-term rentals, then how can they not prohibit them against this woman? And the court said, well, public policy with all these rental rules that we're talking about sort of says we want to make rentals more and more accessible and more available, so that's why. So what this case established was effectively a grandfathering not only for rental types, but also for rental terms. So let's say you had CC&Rs, no rental term required. So right now it's just signing. And the board wants to go to like 30 or 60 or a year. You're gonna have to grandfather in the current homeowners. Now who here has actually heard about this before today? See, you guys also get gold stars. I'm giving you free champagne too. So this is just to be mindful about changes in the terms of rental provisions, period. I'm telling you so that it's, if the attorney that you're working with doesn't raise it as an issue, then you can actually raise it and be like, hey, gold stars for me. So that's the end of my little chat. Does anyone have questions? Am I doing good on time, Jill? Ooh, questions? Yes.
When you were talking about the board being able to amend their CC&R without having approval, were you able to talk about the rental restrictions, or did you have any part of the CC&R without membership?
I love her. Her question was, can the board amend the CC&Rs for any reason unilaterally, or is it limited to the rental restrictions exclusively? That statute is exclusively for the rental restrictions. But I love you that that's where your heart was, because I want to amend them too.